But there are, as I say, several stories in the news that are of great concern to me, and I'm sure to you as well. And the OSHA mandates were big, huge news. And the Supreme Court came down with a decision last night. Here's an article out of the Epoch Times. Supreme Court blocks business vaccine rule, declines to stay healthcare workers mandate. The Supreme Court has blocked the Biden administration's COVID-19 vaccine mandate for private businesses, but has decided to allow a separate regulation that requires healthcare workers to get a vaccine to take effect. In a 6-3 ruling on January the 13th, the court halted the mandate for all private employers with 100 or more workers, ruling that the states and companies that challenged the rule were likely to succeed. Biden administration officials had argued that the Occupational Safety and Health Act, OSHA, of 1970 gave them authority to impose the mandate, but a majority of the justices disagreed. Now, what I want to do is I want to pull up for you the actual opinion from Gorsuch and the justices that agreed with him. And there is a dissenting opinion by, I think Sotomayor wrote that, but I think there's some pertinent points here as to why did the majority, 6-3, that's not even close, right? That's a big majority decision for this. So this is a pretty firm and solid thing that we should be paying attention to. So why did OSHA the mandate not go through? Why did they reject that? I think this is important. So I want to read a little to you from Neil Gorsuch, Justice Neil Gorsuch. It says, I start with this court's precedents. There is no question that state and local authorities possess considerable power to regulate public health. They enjoy the general power of governing, including all sovereign powers envisioned by the Constitution and not specifically vested in the federal government. The federal government's powers, however, are not general but limited and divided. Not only must the federal government properly invoke a constitutional enumerated source of authority to regulate in this area or any other, it must also act consistently with the Constitution's separation of powers. Therein lies the key to their decision. Having authority, something they asked repeatedly during the oral arguments. It goes on to say, and when it comes to that obligation, this court has established at least one firm rule. Quote, we expect Congress to speak clearly, unquote. If it wishes to assign to an executive agency decisions of vast economic and political significance, in which it means that that's not the case. It has not happened. OSHA's mandate fails this doctrine's test. It says, the agency claims the power to force 84 million Americans to receive a vaccine or undergo regular testing. By any measure, that is a claim of power to resolve a question of vast national significance. Yet Congress has nowhere clearly assigned so much power to OSHA. Approximately 2 years have passed since this pandemic began. Vaccines have been available for more than a year. Over that span, Congress has adopted several major pieces of legislation aimed at combating COVID-19. Indeed, and it goes on to say, but they haven't given OSHA this authority. It goes on to say, indeed, a majority of Senate even voted to disapprove OSHA's regulation. Far less consequential agency rules have run afoul of the major questions doctrine. What is OSHA's reply to this? It directs us to 29 U.S.C. 655, a statutory subsection. Congress authorized OSHA to issue emergency regulations upon determining that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, and that such emergency standards are necessary to protect employees from such dangers. According to the agency, this provision supplies it with almost unlimited discretion to mandate new nationwide rules in response to the pandemic, so long as the rules are reasonably related to workplace safety. The court rightly applies the major questions doctrine and concludes that this lone statutory subsection does not clearly authorize OSHA's mandate. Let me skip down a little bit here. As the agency itself explained to a federal court less than 2 years ago, the statute does not authorize OSHA to issue sweeping health standards that affect workers' lives outside the workplace, and therein lies the trick as well. These mandates would not just be related to the workplace, but to the home, to the grocery store, to the park, around the corner, to life everywhere. This would have a sweeping impact on Americans in all of the aspects of their lives, not just the workplace. It goes on to say, yet that is precisely what the agency seeks to do now. Regulate not just what happens inside the workplace, but induce individuals to undertake a medical procedure that affects their lives outside the workplace. Historically, such matters have been regulated at the state level by authorities who enjoy broader and more general governmental powers. Meanwhile, at the federal level, OSHA arguably is not even the agency's most associated with public health regulation. And in the rare instances when Congress has sought to mandate vaccinations, it has done so expressly. Why does the major questions doctrine matter? It ensures that the national government's power to make laws that govern us remain where Article 1 of the Constitution says it belongs, with the people's elected representatives. If administrative agencies seek to regulate the daily lives and liberties of millions of Americans, the doctrine says they must at least be able to trace that power to a clear grant of authority from Congress, which in this case, they cannot. The non-delegation doctrine ensures democratic accountability by preventing Congress from intentionally delegating its legislative powers to unelected officials. Sometimes lawmakers may be tempted to delegate powers to agencies to reduce the degree to which they will be held accountable for unpopular actions. If Congress could hand off all its legislative powers to unelected agency officials, it would dash the whole scheme of our Constitution and enable intrusions into the private lives and freedoms of Americans by bare edict rather than only with the consent of their elected representatives. That's a powerful statement right there. The major questions doctrine serves a similar function by guarding against unintentional, oblique, or otherwise unlikely delegations by the legislative power. Sometimes Congress passes broadly worded statutes seeking to resolve important policy questions in a field where, while leaving an agency to work out the details of implementation, later the agency may seek to exploit some gap, some ambiguity, or doubtful expression in Congress's statutes to assume responsibilities far beyond its initial assessment, or assignment rather. The major questions doctrine guards against this possibility by recognizing that Congress does not usually hide elephants in mouse holes. I love that. That's great. Now, I kind of read that part and thought, the church can sometimes do that, write vague and ambiguous documents and just hope that people on the more local level will fill in the gaps and work things out. But they also sometimes look for those loopholes and abuses set in. It's kind of the same thing, isn't it? This Gorsuch response goes on to say, in this way, the doctrine is a vital check on expansive and aggressive assertions of executive authority. Whichever the doctrine, the point is the same. Both serve to prevent government by bureaucracy supplanting government by the people. On the one hand, OSHA claims the power to issue a nationwide mandate on a major question, but cannot trace its authority to do so to any clear congressional mandate. On the other hand, if the statutory subsection the agency cites really did endow OSHA with the power, it asserts that that law would likely constitute an unconstitutional delegation of legislative authority. Under OSHA's reading, the law would afford it almost unlimited discretion and certainly impose no specific restriction that meaningfully constrain the agency. Either way, the point is the same. One Chief Justice Marshall made back in 1825. There are some important subjects which must be entirely regulated by the legislature itself, and others of less interest in which a general provision may be made and power given to others to fill up the details. The question before us is not how to respond to the pandemic, but who holds the power to do so. The answer is clear. Under the law, it stands today that power rests with the United States Congress, not OSHA. In saying this, And saying this much, we do not impugn the intentions behind the agency's mandate. Instead, we only discharge our duty to enforce the law's demands when it comes to the question who may govern the lives of 84 million Americans. Respecting those demands may be trying in times of stress. But if this court were to abide them only in more tranquil conditions, declarations of emergencies would never end, and the liberties our Constitution's separation of powers seek to preserve would amount to little. And that is most of Neil Gorsuch's comments there. And here's the interesting thing about this story. You know what started the OSHA mandate process? They needed a workaround because Congress wouldn't provide the power. Congress wouldn't provide the authority. They needed a workaround. How do we know it was a workaround? Because the White House Chief of Staff tweeted it to the world, that this was their workaround. That tweet was referenced in the Supreme Court decision. That is how they know this was a workaround. Let that sink in. They were looking for a way to subvert the constitutional process, and they tried this, and it didn't work. Now, why did they let the medical mandates stay in place and block the business one? Well, because Congress acted on the medical side and gave authority in that regard to Health and Human Services, and the Supreme Court decision cited that. And they said, look, they have authority. Congress was clear. They gave authority to Health and Human Services for that, so that has to stay in place, but the business one is blocked. Now, it's all sent back down to the Sixth Circuit Court of Appeals, but at this point, it's a done deal as far as that's concerned. And now, if your company is still mandating, if the company you work for, your friends, your family are still mandating and you're facing layoffs or worse or what have you, it's because the company wants it. It's not because the government's forcing them or they're going to be fined. It's because the company you work for or your friends and your family work for, they want this. So let that sink in, I suppose. Let's pray for Americans everywhere, not just for their health, because we don't want anybody getting sick or dying or worse. But the good news is I saw a report out today, 91% less lethal, this Omicron variant, than Delta. And it's already coming to a peak, and it's going to drop off precipitously pretty soon, according to another article I saw. So let's pray for Americans. Let's pray for our church. Let's pray for an end to the madness and confusion. Let's have clarity.